I'm Sherry Ely. I'm the Program Director for Juvenile Justice with the National Council of Juvenile and Family Court Judges, and I oversee our project for military-connected families in the courts here at NCJ-FCJ. And we have been partnering this past year with the National Organization for Victim Advocacy, also known as NOVA for short, to do a webinar series. And today is the third webinar in that three-part series on addressing non-visible disabilities and military-connected DVSAS cases. We have two staff members from NOVA presenting this webinar today. We have Dr. Ava Ramirez-Ene and Kimberly Henry, who have been with us for the past two webinars in this series. We're very fortunate that our initiative is funded by the State Justice Institute, and the initiative is very much focused on military-connected families who have matters in juvenile and family courts. We do operate a national resource center through the National Council's website for military-connected families in the courts with many resources that you have access to, and we will place a link for that resource center in the chat today. And as I mentioned, this is the third webinar in a three-part series. The first webinar was on bridging the divide, MOUs and cross-enforcement of military protection orders and civil protection orders. And the second webinar was building sustainable CCRs with courts and military partners. Both of those webinars were recorded, and we will place the link to those webinars in the chat if that's something you would like to view. This webinar is also being recorded and will be on NCJ FCJ's YouTube channel within a few days for viewing as well. We will monitor the chat for questions today, but for now, I'm going to turn it over to Dr. Ava Ramirez-Ene to get us started. Thank you.
Thank you so much, Sherry, and good morning, good afternoon, everyone. Thank you so much for joining us. I see a few chats coming in introducing yourself, so please take a moment to do that. We would love to see who we have today in our session. You can say your name, your role, maybe the organization that you are currently working with. And as we move forward, I'd like to really frame today's discussion, and I want to be very clear about what this session is and what it is not. This is not a clinical training. We are not asking courts or personnel to diagnose or suggesting that disability excuses harmful behavior. And we're, of course, not asking anyone to lower their legal standards. What we are doing is really strengthening our understanding and our interpretation. In civil DVSAS cases, domestic violence, dating violence, sexual assault, and stalking, we know that courts often rely on a person's presentation and behavior. We assess credibility quickly, we evaluate the narrative, and we also observe demeanor. And we really make these high-stake decisions, sometimes within minutes. And the challenge is that non-visible disabilities can significantly affect how someone presents in courts without affecting whether they are truthful, capable, safe, reliable. And we use these terms non-visible disabilities when referring to conditions that may not be immediately apparent, but they can influence memory, emotional expression, processing speed, and communications. And these conditions can be connected to military service, victimization, earlier trauma, something completely unrelated to the current case that you all are maybe seeing in your court systems. So what often happens in fast-moving civil settings is that behavior can be interpreted before context is considered. So today we really want to slow down that interpretive process just enough to ensure that we are distinguishing between presentation and credibility and between symptoms and intent. So our goal really is accuracy. And when courts and our court personnel can understand how trauma and non-visibility disabilities impact presentation and behavior, decisions can become more trauma-informed and precise and equitable, and really ultimately protecting not only the survivors, but the integrity of the judicial process itself. So as we move forward, I invite you to listen listen through that lens of understanding and really being open to how we are interacting with the individuals that come through the court systems. So before jumping in, a few moments to introduce ourselves. If you did not catch the previous 2 trainings in this series, my name is Dr. Ava Ramirez-Ene. I serve as the Associate Director of Military Coordinated Community Response at NOVA. I am also a Marine Corps retired veteran, and my work focuses on really strengthening how military and civilian systems respond to survivors, particularly in cross-system cases. And over the years, I have seen how trauma, military culture, experiences, and non-visible disabilities intersect in ways that show up, and how easily presentation can be misinterpreted when we don't pause to consider context or prior experience or victimization. And that really brings me here today is a commitment to improving how we interpret behavior when victimization and trauma are factors that really need to be considered. And I'm honored to be presenting alongside my colleague, Kimberly Henry. And with that, I'll turn it over to Kim.
Yes, thank you, Ava. And I am also very excited to be here. My name is Kimberly Henry, and I'm a licensed master social worker. And here at NOVA, I am the Senior Military Coordinated CCR Program Manager, and also a veteran. I served 10 years in the U.S. Navy. And during that time, I was a sexual assault victim advocate, which led me to my career in social work. And I decided to leave the Navy honorably to be a full-time sexual assault victim advocate for the Air Force. And through those experiences and lived experience, I really gained the passion for program management and policy work and just the program development to be able to support military connected survivors, but really having the drive for communities and military communities, both civilian and military, to work together, primarily focusing on people living with disabilities, specifically within the disability community. Myself, having used a service dog in my own personal life over the last couple years, it has been very eye-opening in what it means to have non-visible disabilities, especially as a woman. And so this topic is very near and dear to my heart, in understanding as a combat veteran and understanding as a survivor of certain forms of DVSAS and what that means, as well as being experiencing some forms of civil courts and being a foster parent and other forms of civil courts, and what implications that has when it comes to non-visible disabilities, and how that can be interpreted in the courts, and how that can really impact families. And so I'm excited to share this information with you again alongside Ava, and we'll go ahead and get started talking about the objectives. We are going to be taking questions throughout the presentation, so feel free to raise your hands, but we will have a Q&A at the end as well if you'd like to save your questions for that time. Go ahead, next slide. So what are our objectives? As Ava shared, we are not here to tell you how to run a courtroom or to justify your legal decisions, but we really want to focus on the process fairness and the access, and not clinical evaluation, especially in the courts. But courts are increasingly becoming familiar with ADA-based access, American with Disability Act access, and the obligations. And this training really focuses on earlier and really less visible issues, and that's non-visible disabilities. And trauma and disability-related behaviors are interpreted before accommodation frameworks are usually even considered. And so for these objectives, we're going to be working through them throughout the entire presentation, of course, but as you see on the bottom, we have a note to have something to take notes on. Not just because you may have questions, but because this isn't a common topic. This is not something that a lot of people are having conversations about in their cross-training within court systems themselves, especially not in systems across military and civilian legal or court systems. So we are going to identify common non-visible disabilities among military-connected survivors. We are also going to apply trauma-informed principles to avoid misinterpretation, specifically, again, about the behaviors and the demeanor that Ava was discussing earlier. We're then going to evaluate impacts on protection orders, custody, and emergency hearings, very common things that we see in civil cases. and then implement courtroom strategies that will promote equitable access, not just to the court proceedings and the outcomes, but also just the approach to communication. And then promote cross-system collaboration across both military and civilian systems to supporting military-connected survivors of domestic violence, dating violence, sexual assaults, and stalking who may have non-visible disabilities from a wide range of reasons and experiences. So just a reminder that this training is very important, and we're very appreciative that you're here, but this training is not about diagnosing survivors. It's not about excusing harmful behavior or lowering standards of the evidence or the standards of the law. It's also not about making assumptions about credibility for one party versus another, but it's really about accurate interpretation and making sure there's equitable participation for those that are involved in these civil cases. And then, of course, procedural justice. So again, as the slide says, please have something to take notes on for questions or anything that you'd like to share throughout the presentation. We will have some scenarios towards the end.
Thank you so much, Kim, for that reminder. And before getting started, let's ground ourselves. We keep saying this term, military-connected survivors. We understand victims are often used, the terminology, but it really is important to pause and really expand on what that means. So often when we hear this term, military connected, people often think of active duty service members serving full-time on an installation, but utilizing the Department of Defense understanding and definition, military connected survivors includes a much broader population that we want to make sure that we are including in our services, our outreach, our marketing. So this includes our active duty, our National Guard, reservists, veterans, and dependents or intimate partners. And that can mean spouses, former spouses, dating partners, someone who shares a child, or someone who shared a home at the time of the incident or abuse. So a very large and diverse population. And what makes this especially important in civil cases is that many of these individuals are navigating two systems at the same time, civilian and military, that dual system navigation can create significant confusion around jurisdiction, eligibility, and confidentiality, and also access to services. For example, a National Guard member who may live in a rural community, but they report to a commander in another state, and they attempt to access some mental health or advocacy services through a civilian agency that may not fully understand military culture. And that fragmentation alone can really become a barrier to safety and healing. Additionally, Guard and Reserve families, they may be eligible for supportive services like counseling if that abuse occurred while the member was in an active status, but they may not be able to file a military law enforcement report unless the abuse occurred on that active status. So National Guard units also may have sexual assault victims, but not domestic violence victim advocates, or some that may be dual-hatted, which may mean families may seek services off the installation. So it's really important for us to have the general understanding of who is included in these services, how can we provide support, and we're not expecting you to be the experts, but really to make those connections with your military victim advocates to know what resources are available to fully support the individuals on this slide. So as I am mentioning this, I would love to see if any of our individuals here are military connected or have military connection through their family. If you want to add that to the chat. And again, we just want to reiterate that when we do say military connected, we are not talking about a small or uniform group. We are talking about individuals that often carry dual identities. They have to operate in dual systems, and also that means dual barriers. And many are balancing the civilian and military expectations, navigating fragmented resources, and really trying to determine where is the best place to seek help, seek services, and who is a trustworthy source to go to. So understanding that broader context really matters because it shapes how individuals are entering the courtroom, what support they have, what stressors they are carrying, and what barriers they have already encountered before they even appear before a judge. So again, this population is larger, more complex, and we really want to make sure we are providing the best resources and services available and having that understanding of the additional challenges that our military population face. And I see several individuals putting in the chat. They are veterans connected to the military. They have family, spouses. Thank you so much. So before moving into further content, we do have a question for you all. Let's see if my slide control, there we go. So to get connected, you can go to menti.com and put in that code. We will also be putting in a link to this question to follow along in the slides. My amazing colleague could do that. Thank you. What we would like to know is which court do you primarily practice in? Civil, criminal, or neither? Go ahead and select that best option that reflects your primary practice area. And as responses come in, thank you for participating. We do have a few mentees, we have a few case studies, and this really helps us understand how much of our discussion should be anchored in the different court dynamics, and understanding that while trauma and non-visible disabilities appear in both systems, we know the stakes in interpretation and interpretive pressures can look very different in civil proceedings. So in criminal court, there are often more clear evidentiary rules, more structured timelines, and defined burdens of proof. In civil court, especially in protective orders and custody matters, decisions are often made quickly with limited information, and that demeanor, behavior, or presentation piece can carry significant weight. So as we see these results, regardless of which court you practice in, I encourage you to think about how presentation of an individual influences your decision-making, how you're interacting with that individual, and how maybe we can be open to changing how we are interacting to be more trauma-informed and understanding to best support that individual and their family. Thank you so much. See mostly civil and also neither, and some criminals. Thank you so much. We are going to be moving to the next slide, which is also a mentee. Thank you, Kim. Our next question for you is, how often do you see trauma or mental health history raised as a proxy for parenting capacity? We have never, rarely, sometimes, often, very often. And this next question really builds directly on what we just discussed. So take a moment to reflect the option that best reflects your experience. And as those responses are coming in, understanding that this is not about whether mental health is relevant. Of course it can be. The issue is when a diagnosis or a trauma history is used as a shorthand for instability, danger, or unfitness without a functional analysis. So in custody litigation especially, we often see PTSD, anxiety, depression, or a trauma history introduced in ways that subtly shift the focus. Instead of asking, is this parent meeting the child's needs? The question can become, does this parent have a mental health history? And that is a very different inquiry. So thank you. We're seeing your responses now. Many of you are selecting often and sometimes and very often. And this tells us that this is not an occasional issue, it is a pattern. And that pattern matters because symptoms that affect organization, sleep, or emotional regulation may be misinterpreted as parenting deficits when they may actually reflect as trauma recovery or healing or a process or life stress that this individual is dealing with and additional barriers because of their victimization or because of their military experience. So as we move forward, we are going to focus on the distinction between diagnosis, functional impact, because that distinction is critical in civil decision making. We do have one more question. Which is a word cloud. So it is asking, when an individual appears disorganized, emotionless, or inconsistent in court, or when you're providing services, what is the first explanation that typically comes to mind? So you can write a word or a phrase that honestly comes up here. These responses are anonymous. There is no judgment. This is all about awareness and sharing our awareness and what we are experiencing in our organizations. Thank you so much for sharing. I see trauma, nervous. The larger the words, the more individuals are selecting those same words. Scared, mental health, overwhelmed, trauma, drugs, trauma, brain. Thank you so much. You all seem very self-aware. Oftentimes when we ask this question, sometimes we say credibility comes into question, invasive, disengaged, unstable, unprepared, or even lying. And so I do want to pause here intentionally with that understanding that our brains are wired to interpret behavior quickly. And that is just a biological response in how we are ingrained. And we understand in the court systems and victim advocacy, there is significant caseload. There's overwhelm. Sometimes we're wearing multiple hats. And that need for efficiency requires a quick action, especially in fast-moving civil proceedings. So we do rely heavily on presentation, but understanding that trauma, the non-visible disabilities more broadly can disrupt quote unquote normal reactions or behaviors. So this exercise, this training is not just about eliminating professional judgment. It's about slowing down that first interpretation just enough to ask, is there another explanation or cause or correlation that can be impacting this individual's behavior or their demeanor? And we want to make sure that when we are talking about our civil cases, particularly custody and protection orders, that interpretive leap can have long-term consequences. So we do want to be cautious and conscientious about how we're moving forward with this individual and how we are best supporting them in their entirety. So from here, we're going to look more closely at the types of non-visible disabilities that commonly show up and how those impacts can interact and intersect. And with that, I'll pass it over to Kim.
Yes, thank you, Ava. And before I go to the next slide, I do want to point out everything that we see here on the screen. You've heard us say many times non-visible disabilities, and what we're not saying is invisible disabilities. And I want to point out before we continue through the rest of the presentation that a key point of that, and sometimes I see this in this question come up in the chat when I'm talking about non-visible disabilities, is why are you calling it non-visible instead of invisible? And that's because everything that you see here on the screen is not invisible. People feeling traumatized, people experiencing trauma, people that are experiencing stress, or that are frustrated, or people shutting down, people experiencing barriers, or that are sad or anxious, those are not invisible in the sense that they don't exist. So a lot of times when you hear invisible disabilities or just the word invisible, it's almost like it's fake or it doesn't exist or it's not real. And so that's why we use the term non-visible disabilities. And so after this slide with all of these terms on the screen and these phrases on the screen, I really wanted you to have the opportunity to see that going forward and what we've talked about so far using the term non-visible disabilities, I want you to keep that in mind as we talk about what are some of the common non-visible disabilities that we see in civil, DVSAS, domestic violence, dating violence, sexual assault, and stalking cases, as well as some of the common non-visible disabilities in military-connected survivors or military-connected individuals. So specifically, non-visible disabilities that we see in these cases regarding domestic violence, dating violence, sexual assault, and stalking are post-traumatic stress or post-traumatic stress disorder, PTS, PTSD. We know that, of course, PTS or PTSD is not something that's continuous and ongoing and never ending, in the sense that someone cannot get treatment for it, or everybody's symptoms are the exact same, or that it's going to happen at a certain time or a certain severity. But we do know that when it comes to DVSAS, that there is a risk and there is a possibility and a likelihood that the individual will experience PTSD. And not only in the sense of the actual victim or survivor, but also witnesses to the experiences of DVSAS. We also know that TBI, traumatic brain injuries, are experienced or are results of DVSAS. And we also know that TBIs are often undiagnosed, but actually common, especially in domestic violence cases that are involving head or neck trauma. And keep in mind, I'm not necessarily only talking about just military connected cases, just in general, when we're talking about domestic violence, for example, with TBI. If you consider a victim or survivor of domestic violence who has experienced a traumatic brain injury, now consider that that person is a military connected individual, and maybe they have gone to combat, or maybe they have been deployed, but not necessarily combat. Maybe they have also experienced the TBI through that experience. And so, or through that deployment, or through that service, or through the different types of trainings or different activities that they've done during their deployments. And so now you're adding two different types of experiences that have resulted in a TBI that can have compounding traumatic results or outcomes. There's also military sexual trauma, or MST, and experiences of sexual assault or sexual harassment that happen during military service are known as MST. This is a term that really started and is used by the VA, the Department of Veterans Affairs, but it's more widely known now, both by society and other agencies, including civilian agencies. But we know from the data that 1 in 3 women and 1 in 50 men answer yes, that they have experienced some form of MST or military sexual trauma. So there are some non-visible disabilities that have occurred or have generated from experiencing sexual trauma or sexual harassment that's connected to military service. We also know that there's depression and anxiety that are non-visible disabilities. And again, the severity level, the significance, the onset, the frequency, all of these things are not exactly the same. They don't occur or represent the same. The treatment is not the same. It can be very complex, of course, but we're not even talking about once they get into the courtroom. This is just what can happen, the non-visible disabilities that can occur once someone has experienced DVSAS. When we get into the courtroom, and just in general in society, to be honest, we know that one of the first places that biases show up is when we assume that we know where a disability comes from. And that's why here on the title of this slide, you see that it says origins are different, but impacts can overlap, and they may overlap. So when we assume that we know where a disability comes from, or that it comes from a single source, that's when we start to apply bias. Some disabilities are connected to military service. Some are connected to DVSAS, so the domestic violence or sexual assaults, and some are from both. So there actually is some overlap. But what's extremely important is that the origin does not tell us anything about a person's credibility. It does not tell us anything about their parenting ability or their capacity. Just because it is maybe connected to multiple sources, it could be not even connected to the current case at all. So for example, if you can kind of visualize something with me, as a woman with a service dog who has now since retired, and she is living her best life on our property. She's gained a little bit of weight, but she loves her life. But she is a 10-year-old black lab. And as a woman with a service dog, I was many, many times asked, the first question is, were you in the military? And I would say, yes, I was in the military, of course, would be my answer. And the second question I was always asked was, were you in combat? And it was that immediate bias of, she must need a service dog because she was in combat. But also there's that immediate doubt because a lot of people know that women in the military can't really serve in a lot of combat roles. So not only are they doubting my service or what I did in service, but they're doubting the non-visible disabilities that I may have because of why I need a service dog in my time in service. And so my answer to that would be yes, I actually was served in combat twice. And sometimes I get additional questions that maybe weren't appropriate. But you would see that immediate bias would come from the assumption that they knew where the non-visible disability would come from, because physically looking at me, there was nothing wrong with me. But I did need a service dog for a period of time because of non-visible disabilities. Again, as it says here on the slide, from things that overlapped: pre-military trauma, military service, DVSAS victimization. And so it's extremely important that when we go to the courtroom, that we're not applying this bias. Through that time of having a service dog, I did adopt my two nieces, and I was able to do that because that bias wasn't applied. If bias of non-disabilities was applied, you have to consider, would I have been able to follow through with that adoption or not? Because what's important to remember is that non-visible disabilities are not inabilities. Courts often do encounter disability after another system has already assigned meaning to it. And what I mean by that is like law enforcement or child protective services, or even medical providers. And look at records, for example, medical records. They could have assigned treatments or the treatment options that have either actually been carried out or treatment plans that haven't been carried out and followed, or medication, maybe law enforcement. There has been some legal issues or run-ins with the law, or not follow through with certain requirements of criminal repercussions, maybe not following certain orders with criminal courts. And so there's already sometimes been definitions or requirements or meanings assigned to a disability without actually identifying that those experiences that people have that are now causing issues within someone's life, that are now kind of flowing over into someone's civil case or civil issues in their life, are now actually creating more challenges for them. So if courts don't pause here and ask, well, what can, one, we do to help? And two, are we applying any bias? Then we actually risk importing assumptions instead of actual evidence into that case. So we're going to have some examples and scenarios and later on in the presentation, but I do really want to clarify something in this training, is that when we're talking about disabilities in court settings, we can really look at two different things that can help us identify, are we applying bias, or are we just doing what we're supposed to be doing and making sure that we're giving everyone equitable access, or are we just kind of checking off our things in the box? And those two different mindsets of what you can think about is, one, your ADA obligations, and two, trauma-informed interpretation. And so when you're looking at non-visible disabilities not being inabilities, they're going to fall under these different 4 bullets here. One, considering that a diagnosis does not equal incapacity. So if there's already been a meaning assigned to it from law enforcement or CPS or medical providers, doesn't mean that just because this person goes to counseling every single week, doesn't mean that they need a ton of ADA accommodations. But it also doesn't mean that you have to approach them as they're fragile. And you know what, maybe they can't handle getting full custody of their kids and they won't be able to take care of them. That's applying bias. There's military connection, but that does not equal cause. Just because I have a service dog and I was in the military doesn't mean my trauma came from combat. Just because I've gone to combat doesn't mean I experienced trauma while in combat. Trauma history also does not equal risk. And so if there is that trauma history there, whether it's prior military or during the military or after the military service, does not automatically mean that, well, this person has been to combat or this person has experienced domestic violence. And so they may, likely offend, or they may not have dealt with it. So they could be a risk to their kids, or they may not be able to really be in the right state of mind to go through this divorce or to be able to care for themselves. And so there Actually, again, having bias apply to them, that's not fair.
Not like that.
And then also, disability does not equal unfitness. So what you've heard me say a few times now is that just because there is a non-visible disability or any disability, but in this presentation talking about non-visible disabilities does not mean that someone is unfit, whether it's to take care of themselves, to be a parent, to be a caregiver, to make decisions on their own behalf. If it is something as going through a divorce or making decisions about property or things that they have ownership of. And again, when we're talking about civil cases, we could be talking everything ranging from family, divorce cases to custody, and again, to ownership of certain properties and items. So I mentioned the ADA obligations and trauma-informed interpretation. ADA obligations are requirements, right? But ADA obligations are the minimum requirement. That does not mean that it's a check in the box and say, well, we met the ADA obligation, we're good to go. You can always go above and beyond the ADA obligation because they are the minimum. But what you do need to make sure is that you're not applying it as it's a stamp or a sticker that you're putting on someone's shirt when you're recognizing, oh, this person has disabilities, visible or non-visible, and saying, well, we've met our obligation for the ADA, we're good to go. You're putting a label on that person. But what you can do is you can ensure that there is equal access to court services and proceedings. Not everybody is comfortable coming into the court, even if they're physically able to. Coming into a courtroom setting can be a lot like coming into a commander's setting where you're being put up against the, you're kind of like the Uniform Code of Military Justice, and maybe you're putting up against an Article 15, and that person may not be in military uniform, but they're in a courtroom setting, and it can be extremely overwhelming for them. Maybe they were a victim of sexual assault in the military, and they reported it. Once they made the report, they faced extreme retaliation, which we know happens in the military. And now you're asking them to come to court for a simple civil hearing that could be done online over Zoom, but this is how your court does things. So that's just how you're going to do it, is they need to appear in person. Are you really being accessible to non-visible disabilities? Probably not. You're probably in maybe considering, well, they look like they can make it here just fine. They look like they can sit in a room just fine, but you're not being considerate of non-visible disabilities. Also address communication and participation barriers, similar to the example that I just gave, and focus on reasonable modifications. There are many, many reasonable modifications. I understand sometimes it's like our courts do not have the funding, we don't have the personnel, we do not have the time. 100% get that. I live in a very rural area of Texas. We are very limited on our resources. However, stop and identify what are some of our reasonable accommodations for visible and non-visible disabilities, and when can we implement them? And other ADA obligations are triggered when disability-related access needs are identified. And you can do that before someone walks into your courtroom or comes and connects with your courtroom or communicates with your courts that they do have a disability need that needs to be accommodated. You don't have to wait until someone approaches you with it. But then there's the trauma-informed interpretation, which addresses how behavior is understood and how it's interpreted. I'm sure many of you are here today because you have awareness or understanding, or you've worked with trauma-informed either roles, or you've been in a role that has to be trauma-informed, or you've already received some trauma-informed training. And if you never have, that's great. I'm happy that you're here. But you know how important it is understanding that what it means to be trauma-informed and the impact that it's going to have on your courtrooms and on the legal system, both civil and criminal. And this is because by being able to better understand the behavior that someone is exhibiting, by being able to understand why they're presenting a certain way, or maybe why others are responding to that person a certain way, is actually helping you make a better informed decision in these legal decisions that you're making or that the courts are making. And that requires that you be trauma informed. So addressing how certain behaviors are happening means that you are being able to identify maybe they have some non-visible disabilities. How have you communicated that with them? Have you asked? How do you ask? What does that conversation look like? How trauma informed is your team? What do you do when you identify that someone has non-visible disabilities? How do you take that into account in your cases? There's so much that can be packed into this first bullet is how to address how behavior is understood and interpreted in your courts. Also recognizing how trauma and, again, non-visible disabilities can affect presentation, which is similar to what I had just stated just a second ago, but being able to recognize in the sense that they may seem like everything is going fine and comfortable in one hearing, and then the next hearing, they are all over the place. Immediately, are you thinking, what happened since last time? Or maybe are they upset with what I've given them because I've given, plenty of help and opportunities? Or why are they choosing to behave this way? Kind of what's their problem? Well, clearly they're not getting the help that they need. What are some of those thoughts that are happening? And it may be biased, but what are some of those thoughts that are happening that you may need to address with your team? So when a situation happens where someone is presenting a little bit differently than normal, than they normally are, that you're able to address it appropriately. And again, trauma-informed interpretation applies even when no accommodation is requested. I will tell you, as someone who has had a very visible accommodation, which is a service dog, I many times felt that I was accommodating the rest of the world rather than being accommodated. Whether it was asking the person next to me on an airplane if they're scared of dogs, to having to wait on the other side of a department store because there was someone there afraid of dogs and having to get help on the corner of the department store. Just constantly being the one who was really accommodating other people. When it comes to applying trauma-informed care, people who need accommodations do not want to have to ask for that accommodation. And most likely they probably will not ask for an accommodation. So what can your courts do to have a trauma-informed court area, courtroom, court setting, and court process to ensure that it's comfortable to where people, not only do they not want to, but they really don't need to ask for accommodations because you've made it a trauma-informed setting. And then focus on fairness, accuracy, and credibility assessments, ensuring that people feel that when I walk into this courtroom, if I get asked, have you been diagnosed with PTSD? Or I see in your record that you've been diagnosed with PTSD, the first immediate feeling that that person is going to feel is like, oh, now they're not going to let me have custody of my kids. That's not going to be the feeling that they feel. Instead, it's going to be, they're asking, they just need to know, they want to know my treatment and if they can provide me any support. That's what you want the people in your courtroom to feel, not that instant fear that a lot of times people with non-disabilities may feel. We have another Minty here for you. So I'd like to know, on a scale from 1 to 5, how confident do you feel distinguishing between credibility concerns and trauma-related presentation? And so what I'm asking here is, when someone is presenting a certain behavior, are they being credible or not credible? Or is it actually related to trauma? So is someone showing up, and Ava had already asked you a question earlier, when someone shows up disorganized and kind of out of place and kind of a mess, what are you thinking? Are you able to identify, is this person just not having any credibility and they do not know what they're presenting today? Or is there possibly something that's happening that's trauma related that they may need support with? How confident are you in distinguishing those two different situations?
Can you click show responses, Kim?
Yes. Okay. Looks like we're kind of in the middle. Okay, and that is okay. We are going to give some examples of what are some of the modifications and reasonable accommodations that can be made, but also some of those things to look for. because here are how some of these things may present in court. One of the ways that these kind of credibility concerns can be presented in court is inconsistent timelines, but actually it can probably be a trauma-related response. We know that when it comes to trauma, especially of course in DBSAS cases, regardless if it was 5 days ago or 5 decades ago, inconsistent timelines are very, very common in DBSAS cases. Now, when it comes to courts, timelines are extremely important in cases, right? But if you're having an inconsistent timeline, credibility is immediately questioned. Unfortunately, if someone has experienced trauma, it's not a credibility issue. It could be, of course. We're not here to say that anyone who's experiencing non-visible, who has a non-visible disability or who has experienced trauma, they are always given their credibility and it's not necessarily not questioned, but you have to consider the question I just asked you. How can you and how confident are you in identifying the difference between credibility and trauma related presentation? If an inconsistent timeline is presented in your courts, what does that mean? Does that inconsistent timeline mean they're just not credible, or does it mean that it's related to the trauma that they've experienced? Another is limited emotional expression. I've seen this also many times where people, they're not crying, so it must not have bothered them. I have actually heard both law enforcement and legal personnel in a couple of different cases, probably about 4 or 5 times total, I have heard it verbally expressed that that person isn't even expressing any emotion, so it must not have been that bad, or they must be lying. So they're immediately having their credibility questioned because of the lack of emotional expression. When by being that person's victim advocate in 3 of those cases, I knew for a fact it was almost like that person had no more emotions left in their gas tank to express. They were exhausted when it came to the emotional expression. But their credibility was questioned because of that, when really it was trauma related. Another is difficulty answering open-ended questions. In trauma, you're required almost to justify everything that's happening to you, especially in a military environment. In a military connected environment, you are feeling the need to define, to clarify, to explain, to justify. And a lot of the times in those open-ended questions, you're trying to give all that information while also sounding credible, while also having to acknowledge that something's happened to you. And how do you answer that, especially to someone who is really good at asking and answering questions for a living? And that's the person you're answering to. Sometimes in a room full of strangers, including a jury, right? And so difficulty answering those open-ended questions really can make people have the sense of lack of credibility again, but it's a trauma-related response. And then the last one, but this is not a end-all be-all list, is appearing confused or withdrawn. That's just a dissociation, just disconnecting completely from what's happening or disconnecting from the case, or it's kind of like a safety response. I need to just step aside, and not physically can someone always step aside. So they have to emotionally, mentally, just really withdraw themselves from the current situation. So these are behaviors that courts can encounter, regardless of what the diagnosis is, but these behaviors are real. But the question is, how is the meaning assigned to them? Go back a few slides when I said law enforcement, CPS, medical professionals may have already assigned meaning to some of these behaviors. Law enforcement may have already said this person's timelines have been very inconsistent. What does that mean, right? Why are their timelines inconsistent? And how does that play a role in the decisions you're making? So what are some of these common misinterpretations? Here's what courts can sometimes assume: that they're not credible, that they're evasive or disengaged and uncooperative. But what could actually be occurring is that it's a trauma response, or that someone is experiencing cognitive overload or neurological impairments. And they're just frozen in the sense of, I don't know. And as soon as you hear the words, I don't know, that is another huge hit on credibility, right? And so it's important to remember that trauma affects how people communicate, but not whether they are truthful in what they're communicating about. I have another mentee for you. There we go. So we'd like to know what concerns or fears come to mind when thinking about civil cases involving individuals with mental health and non-visible disabilities. And this can be your own concerns or concerns that you've heard from either survivors that you've worked with or even law enforcement or partners, community partners that you work with. But what concerns or fears come to mind when thinking about having these civil cases where there are going to be individuals with either mental health or non-visible disabilities? The communication gaps, safety for all. Are we meeting their needs? Definitely. Being unbelievable and not being understood. Making sure that the judge understands. Oop. I have to scroll down with this thing. Okay. What if I'm wrong? Misunderstood. How to refer to adequate resources. The judge is weaponizing traumatic events and continuing to uphold bias towards veterans. Definitely. Again, just being a veteran sometimes is like an automatic, oh, something must have happened to you, right? You must be kind of messed up. And especially if you say combat veteran, it's very harmful. Yeah, all definitely some very valid concerns. So what are the impacts of these concerns? The impacts of these concerns on civil cases, when we're talking about things like emergency hearings, protection orders, child custody disputes, guardianship proceedings, and divorce cases involving abuse. I will tell you that living in Texas, you cannot get a divorce when you're pregnant. Even when the woman is pregnant, even if there is a protective order or domestic violence, a judge can order a special order case, essentially. I don't know about every state, but again, I live in Texas. But there can be a special circumstance, but it is very, very, very rare. So even in the sense of a woman being pregnant and trying to file for divorce, she cannot do that until the baby is born if she wants to get a divorce. And even with domestic violence, even with a protective order, and that calls into question the mental health of the victim, the mother, in that case, and the guardianship and the divorce case involving the abuse. After the baby is born, the divorce case can proceed, but then you also have to call into question what can happen after a baby is born. There can be postpartum, and then there's the domestic abuse that had happened. Are there any mental health concerns or non-visible disabilities as a result of that domestic abuse, and if it occurred during the pregnancy? So all these different factors start to come into play. And on top of that, what if one of the individuals, whether the alleged offender or the victim, what if they were connected to the military? And now on top of that, what if they're about to move or they were in the middle of deployment and they're coming back from deployment? So many different factors that are added into these civil cases, especially being in the military, because we're traveling, we're deploying, we're moving, we have cross-jurisdictional issues, but there are extreme impacts on these civil cases because of non-visible disabilities and not because of non-visible disabilities, but because of the misunderstanding and the lack of information and application of trauma-informed care when it comes to non-visible disabilities in these civil cases. So some key concerns when it comes to these civil cases, for example, emergency and protection orders, is limited preparation time. If someone is a victim of DVSAS, domestic violence, dating violence, sexual assault, or stalking, and they are filing for emergency or a protective order, they may have limited preparation time. And in that, there's very high emotional stress. There could be other immediate safety concerns, including things like firearms, which are higher accessibility when it comes to the military, and then more rapid credibility assessments because of the military. We have seen where a victim may not be the the service member. It could be maybe the offender would be the service member, but the alleged offender being the service member, sometimes it's actually given that alleged offender more credibility because they're the service member. And how can the victim say this against the alleged service member? But we've also seen it happen the other way, but that bias creates challenges there. So again, there are definitely implications here. Also in custody and parenting cases, there's been trauma history used against survivors. Well, you've experienced this in your past, so are you sure that that's not going to be perpetrated by you with the children and that you're now taking care of, or against your own children? There could be symptoms framed as parenting deficits. Well, you seem to need a lot of appointments for yourself, or you seem to need a lot of care for yourself. Is that something maybe you should be focusing on, and that's going to detract from taking care of your children? That could be a symptom framed around being able to be a proper parent. And then disability mistaken for instability. And that, again, coming from non-visible disabilities and the misunderstanding of it, and the bias and assumption of knowing where that disability came from, and the level or weight that it holds on that person's life. And then, of course, there's self-represented litigants. So trauma and legal complexity going hand in hand while trying to represent yourself and just trying to update custody orders, or just trying to deploy and you need to update your certain legal custody paperwork to be able to deploy and have a safety plan, or filing for divorce because you're going, before you're going on a deployment and you want to get it done before you leave, or returning from a deployment, or going to different places in orders in the military, or not even being active duty, but being a veteran. And someone's experienced something while they were connected to the military and active duty. What does that mean for them in their trauma, trying to represent themselves, but the legal complexity of that? They live in this state, but something happened in that state, and the person that they are in a civil case with lives in this state. It can be extremely complex. And there's also those executive functioning demands. They're going through a civil system, a civilian civil system that they are not familiar with because they're used to the military system. And then difficulty navigating those procedures.
Thank you so much, Kim. Great information to consider. And we move into what courts can do before, during, and after the hearings. Kim, your conversation spurred a lot of questions and conversation in the chat. Thank you all for really engaging there. And if I missed any questions or comments, please re-add those to the chat and we will address them. So before the hearing even begins, there are small but powerful steps courts can take to really improve participation and accuracy. And again, we want to be very clear that we are not asking courts to diagnose, treat, or excuse behavior, but what we are asking is that we interpret that behavior carefully, avoid assumptions, and ensure equitable participation. Those are judicial skills, not clinical ones. Just as Kim was saying, understanding all of the expanse and intersection of that potential victimization or trauma. So one of the most important steps is setting clear expectations. Many individuals entering civil court, especially self-represented litigants, do not fully understand the structure of the proceeding, the order of testimony, or what will be expected of them. And when trauma or a non-visible disability is present, uncertainty increases stress and cognitive overload, just as Kim was saying. So when we explain what will happen, how long it may take, and when someone will have an opportunity to speak, we create predictability. And predictability promotes regulation. And when people feel less activated, they are able to participate more clearly. Using plain language is another critical step. Legal terminology can be confusing, and even under ideal circumstances. And when someone is anxious, overwhelmed, stressed, or has experienced functioning challenges, comprehension can become more difficult. So being clear, straightforward, and having explanations really improve understanding without changing the legal standards. It is also helpful to normalize clarification. Something as simple as saying, if you do not understand a question, please ask for it to be repeated or rephrased. That can signal that participation is a shared responsibility. I know sometimes there can be pushback where we've heard we cannot accommodate everyone. There's only so much we can do. But courts already do provide accommodations. We ensure language access, we ensure physical access, we ensure hearing access. Addressing non-visible disabilities is simply another form of equitable access. This is not about giving trauma too much weight or greater risk, is giving it too little context or allowing it to become a shortcut in interpretation. So these adjustments are not special treatment. They're access enhancing practices that really improve the reliability of what the court hears. And these small changes can significantly improve participation and accuracy. So what courts can do during the hearing. Again, interpretation becomes even more important. This is the moment when we are actively observing, processing, and making meaning in real time. And when someone appears confused, disorganized, or overwhelmed, there are choices in how we respond. One option is to draw an inference. A more accurate option is to pause and clarify. If cognitive overload appears to be happening, adjusting the pacing can significantly improve the quality of the testimony, slowing down, breaking questions into smaller parts, also asking structured, specific questions rather than broad, open-ended ones. These approaches can really help individuals with trauma-related recall challenges. They can provide clear and more reliable information. I also encourage a simple internal check during a hearing, asking, what am I observing? What assumptions may I be making? And what alternative explanations could fit the facts? That brief pause can prevent an interpretive shortcut or a bias or stereotype that influences how we are responding and interacting. So really separating the demeanor from credibility is critical. Emotional expression varies widely. We understand that flat affect does not necessarily indicate indifference. High emotion does not necessarily indicate instability. Trauma can be blunt affect, it could intensify it. And as someone mentioned in the chat, even potentially being in the same courtroom with the offender or the alleged or the individual that caused harm can really influence how that victim survivor and maybe their family members are showing up. Those are all normal responses. So the focus should really remain on the content and consistency within that context, not on whether someone presents in a way that aligns with expectations of how a quote unquote credible person should look. These practices protect not only that individual in front of the court, but also, again, that integrity of the judicial record. When interpretation is careful and intentional, that outcome does become more defensible and more accurate. I'm just making sure I'm not missing anything in the comments. Thank you so much, Kim, for grabbing those. So after the hearing, moving into this conclusion of the hearing, access considerations do not end. We still need to be clear about the orders, the deadlines, the paperwork. The next step is going to be essential. We understand that it might need to be reiterated more than one time. Maybe it needs to be written down. Or we can also ask how that person best processes or learns or can really accept that information in a way that is digestible and accessible. We understand that trauma and executive functioning challenges can really affect the retention and organization of information. So simply issuing an order without confirming understanding may unintentionally set someone up for a non-compliance. So take a moment to clearly explain what is required, when it is required, and what happens next will strengthen the procedural fairness and ensuring that individual is able to show up and be compliant. It can also be helpful to identify when referrals or additional supports may be appropriate. It does not mean stepping outside of that judicial role. It may mean recognizing the fragmented or multiple systems that this individual is working through. And this is where it's very important to have the connections with the victim advocates, whether it's in the court system, the military system, social services. Where can we do a warm handoff for that individual to make sure they are fully supported and there's not gaps in the systems? Small clarifications at the end of this proceeding can reduce further confusion. It can prevent missed deadlines and unnecessary returns to court. And just having these modest adjustments can, again, significantly improve the equitable participation and, again, that accuracy of the outcomes. So as I was just mentioning, cross-system collaboration, as we've seen potentially in our previous trainings in this series or other trainings you may have attended, no single system really sees that full picture. And so military connected survivors, as we've talked to, I know we might sound like a broken record, but we do that intentionally. They're often moving between multiple systems, civilian courts, military command structure, victim advocacy, veterans affairs, community-based services, military-based services, and each system holds a piece of the story and very few will hold all of it. So when courts are evaluating behavior without understanding that broader context, maybe service history, trauma exposure, access limitations, or prior system responses, that interpretation becomes complete. That cross-system collaboration can really help improve accuracy, well-rounded support. And when we're talking about supporting victim survivors specific to the military, we understand that there are different challenges. As Kim was saying, they might be moving, they may be working with court systems across different state lines. And it's very important that we have connections and communications with the different systems that are supporting that individual. And oftentimes, as we know, especially military connected victim survivors, they may trust one system more than the other. Maybe it's the civilian victim advocates. Maybe that civilian victim advocate has more of the context that could be supported in the court system, or maybe it's the military victim advocate or their legal representation. Collaboration, we understand, does not mean sharing protected information improperly. It really means building the relationships between the systems so that referrals become smoother, that we reduce that fragmentation and really improve communication to prevent survivors from falling through the gaps. And when all of these systems that we've mentioned communicate effectively, fewer cases can escalate unnecessarily, behaviors can be interpreted more correctly, and that participation improves. Ultimately, we understand that collaboration, coordinated community responses really strengthens both survivor safety and judicial precision. So what courts should avoid? So we've spoken to it a little bit already, but what is important to understand is speculation about mental health. We need to be very cautious about drawing conclusions about diagnosis, severity, or capacity without evidence properly presented before the court. And when mental health becomes assumed rather than established, it can unintentionally shift the focus from those facts to inference. And the second avoidance is penalizing trauma responses. We understand trauma can impact every individual very differently, whether it's pacing, eye contact, organization, communication. And when those responses are interpreted as defiance or evasiveness or instability without context, the judicial assessment may become distorted. And the issue is not whether behavior is relevant. It really is whether we are interpreting it accurately and being trauma informed and supporting the victim survivor with their accessibility needs and the accommodations. So third, we want to avoid over pathologizing survivors. Not every emotional response is a disorder or connected to a victimization or connected to a trauma. Not every inconsistency reflects illness. Sometimes individuals are just under extreme stress in a high stakes environment, and labeling normal stress responses as pathology can really undermine both fairness and dignity, and is not fair to that individual. Lastly, inferring intent from affect. Again, emotional expression varies widely. Some individuals become very expressive under stress, other becomes flat or contained. And military culture, speaking from experience, I'm sure both Kim and I can, it often reinforces that emotional suppression, that pushing through even when you are falling apart or you're experiencing extreme stress or physical or mental health challenges or pain. And so having that flat affect, again, being a military connected person or someone who served in the military, it does not automatically signal credibility or lack thereof. And again, the danger is not that courts give too much consideration to trauma or non-visible disabilities. The danger is that trauma or non-visible disability becomes a shortcut to either discredit or overgeneralize and make decisions based on something that is inaccurate. So it's really important that we avoid these pitfalls. Again, protects that judicial neutrality and strengthens the accuracy of decisions. So we are going to be moving into some scenarios, and I will be passing it over to Kim.
Yes, thank you. And we did have a question in the chat that I wanted to answer real quickly, but it was just about that Lori mentioned that they struggle with presenting evidence to the court regarding non-visible injuries, particularly with financial constraints for full evaluation and or expert testimony. And I just wanted to state that, yes, this is a very common challenge. There are full evaluations and expert testimony. Of course, that can be very helpful, but it's not always reasonably accessible, especially financially. But there are ways that you can gain that needed information, and you don't have to have a comprehensive diagnostic evaluation to understand the trauma-related behaviors. And so think about it this way. You're not diagnosing. So you're not asking, well, what is the diagnosis? And you're not asking an expert for that. Instead, you're really looking at what is the functional impact that's observable in that proceeding or in the proceedings. The information that could be helpful, and I went ahead and typed this so it can be in the chat, but the information that can be helpful for courts to be able to make an informed decision is things like documented treatment history. And you don't have to have all the clinical testimony. You could also look at VA disability ratings that the person is a veteran, if it's relevant. You could also look at medical records that are just noting cognitive or stress-related symptoms. And then courtroom observations. So processing speed or overwhelm, or is there difficulty recalling information under certain stress? And then also, it is important to, again, remember that individuals who can provide testimony that are regularly interacting with the individuals involved in the cases. So caseworkers, social workers, and sometimes even family members can provide relevant context without actually requiring expert level testimony, because you're not trying to diagnose, and you're not establishing the symptoms from a diagnosis. Rather, you are trying to establish what's the consistency, what's the history, and what's the functional impact. And I think going into the scenarios would be really helpful And so I know to make sure that we don't go over on time, I'll start with one scenario. And if we have time, we'll go back to the other two. But I'm going to go ahead and do scenario number 2, which is a custody case. So in this scenario, we have a survivor who is a veteran and a single parent, and they are requesting modifications of their existing custody orders. So they have a history of PTSD and anxiety, which has been disclosed to the court. And the parent has otherwise, the survivor veteran has otherwise complied with any visitation and safety orders, making sure that everything that they're supposed to be doing, they are doing. It sounds like in this case, they have maybe been limited on their visitation or their custody, and they're requesting to have more now that they have complied with all the visitation and safety orders. However, the parent has missed some filing deadlines and appears to be a little disorganized. The opposing counsel raises some concerns about stability of that parent. And so my question to you is, what assumptions might be made here in this scenario? What are some of the assumptions that are happening? And you could put that in the chat if you'd like, or you can come off mute if you'd like to do that as well. But what are some of the assumptions happening in this case? Okay, that there's the mental illness, and maybe that's causing an issue, that the survivor is not reliable, and their mental health struggles have made them unable to parent. And that, yeah, an assumption too is that there's substance misuse. Okay, good point. Thank you. That the PTSD affects the ability of that person to be a parent and their responsibilities, that the disorganization and missing deadlines somehow affect the competency to parent. Competency to parent. I think that's a very good term, or a very good phrase. Making assumptions about parenting, and that this organization may appear the person is scattered in thinking and can't organize, which would impact parenting. That they're overwhelmed and not working on their PTSD and anxiety, and that the survivor is not competent mentally. Okay, yeah, definitely. These are all assumptions that can definitely be made here. So then what information is relevant versus what information is prejudice in this case? What information could you say is very relevant in making the decision if the existing custody order should be modified? If this veteran, this parent should get more parenting time, what information is relevant in that decision? Cece said, because of what everyone has said, this is why folks are often unwilling to share everything. Once it's known, you can't take it back. 100%. And not only share, but that's also why they're unwilling to get help, right? Compliance with orders and the safety of children. They need a capacity to do parent evaluation. Yeah, getting one of those evaluations could be helpful, especially in the community. And this is where Ava and I have many trainings, and we've even done one here in this series about civilian and military agencies working together, and the CCR collaboration efforts of just different agencies and individuals being able to collaborate and coordinate services and programs, because there may be a community agency that provides free parenting evaluations that could be really helpful in this case, or there may be a military agency that this community didn't know about, where the military agency provides free parenting evaluations that will do it for the civilian courts and they did not know about. But it takes that communication and collaboration across agencies, that cross-sector collaboration to know this. That could be very helpful here. That they've complied with all orders. They check to see what has changed about the circumstance and if it's temporary. And yes, additionally, what resources might be helpful. If a parent is missing filing deadlines and appears disorganized, we also have to keep in mind they're not a lawyer. They are not a court official. They are not court personnel. I like to say I love paperwork. Sometimes people will say that I'm silly for saying that, but I like to do paperwork and I will miss deadlines sometimes. Paperwork, especially in a legal system, is not the easiest thing to manage. And if you have someone who maybe doesn't like paperwork, or someone who definitely does not do this every day for a living, is trying to file paperwork, and legal paperwork at that during certain deadlines, that it's not very clear, does not necessarily mean that they don't have the capacity to be a parent, especially what if their focus on paperwork is the focus of what they're doing in their children's school and paperwork, and activities, getting their kids registered for sports, but actually their focus is other types of paperwork, and that's being a better parent and being involved in their kid's life, right? And so looking at it from a different frame and perspective can be very impactful in this case. So, yes, all great answers, and I really appreciate you all for participating. But it's extremely important that courts do routinely assess the non-visible disabilities that could be playing a role in these cases. Think about the physical, like parents that may be living with disabilities or chronic pain, or physical disabilities that, again, are very visible, that could limit driving or can limit the ability to be employed. In some ways, people think, in a lot of ways, those are easier to make decisions about because, well, they're visible and they're just easier to understand. But being able to communicate and understand the non-visible disabilities are just as critical, to be able to make informed decisions in these cases. Let's see, we'll do one more Minty. So when PTSD appears in a case record, what is its most important role in court decision making? Should it increase concern? Should it be dismissed until there's a clear proof of harm? Or should it be evaluated with context and functional impact? Or should it determine capacity? What's the most appropriate role of court decision making in the court decision making? Yes, it looks like most of you are answering that it should be evaluated with context and functional impact. Definitely. Again, I've stated, and I share this very openly, that I did have a service dog, but I do not have a service dog anymore, not just because she's retired, and I think she understands that word more than any other word in her service dog language. But she's retired and she's done, not just because of her age, but because I was, assessed and not needing one anymore. But that doesn't mean that PTSD in a case record, that it should just automatically increase concern because, oh, this person has a service dog, or, well, this person went to combat, or, well, this person was a victim of domestic abuse for 15 years. So they're probably not the best. They probably can't handle being a parent. They probably still need to work on themselves. So those are things that you think may sound silly. But again, all of you in this room probably know those aren't silly things because they've actually been said. Their actual bias that has been there and has impacted cases. And that's why we're here today, is to try to prevent that from happening in the future. So the key takeaways is that justice requires seeing beyond what is immediately visible, because non-visible does not mean that it's not significant. It does not mean insignificant. And behavior does not mean intent. Someone being disorganized as a parent does not mean that they don't care. It doesn't mean that they're incapable of getting their kids to school on time, or feeding their kids, or getting them enrolled in school, or taking care of them. Access improves accuracy. So being able to not just have access physically to the court, but being able to be comfortable in a court setting, especially when it is a civil case. So it is something personal. It is something regarding a divorce, a marriage, kids, family, caregivers, maybe even adult caregiving, right? It is something very important to somebody. Having access to a fair, equitable, comfortable environment improves the accuracy of both, really of all parties, including the court's informed decision making. And that fair process strengthens outcomes, not just for the parties involved, but also the community as a whole. And so I'd like to know, what is an assumption that you will reconsider after today's session? What is something that you would like to, maybe after today, that you're going to maybe think twice about or just reconsider? What happens when someone's showing not much emotion? Okay, that's good. Be aware and listen more. And then Cami, I saw in the chat, and I think in an earlier slide, you said this person is a victim and so they will pick another abuser. That is what some have been told. Yeah. And that is an assumption as well that you could even answer here is hopefully other people will not have that assumption anymore. Thank you for sharing that. Just checking your assumptions. Question your own interpretation of what you're seeing and bring resources as each case varies. Yes. And saying that all of these responses, thinking before judging and having trauma-informed care will look a little different for service members and veterans. All of you here today, I don't know all of your roles and all of your jobs, but I say, I want to say that I truly appreciate the work that you're doing because it's not easy. A lot of you do have, many of us in this work have very limited resources at our disposal and very little time and funding to be able to support the work that we're doing. And it does take a lot of the kind of boots on the ground work that you do to be able to do this kind of, to be able to have success and impact. And so I appreciate you taking that second to say, what can I reconsider after today's session? We develop tools to be able to help you do that. This is one of our tools, the Military Civilian CCR Team Development Toolkit. There's a QR code here, and we can also put the link in the chat for you. And it allows you to basically help you develop the skills to be able to identify how you can build a partnership and a CCR, coordinated community response, with civilian agencies and military agencies to work together to support military connected survivors. Eva, I'll turn it over to her to share some more resources.
Yes, I know we're getting close to time, and thank you all so much for joining. We have additional resources on non-visible disabilities. We also have a organizational self-assessment, which we will send out these slides in PDF form, so you can access all of these different resources that can really help you understand military connected population a little bit better. And we do have a military connected survivors website that we are very excited that was recently published that is also going to host all of these resources. We are very excited about it. I hope you check it out. And with that, we're going to move to 2 minutes of our question slide. And I'll just leave the slide up so y'all can access the website. Are there any outstanding questions? You have the option to raise your hand or put them in the chat. Again, thank you so much for joining us and being open to learning how to really support this population with these specific challenges and unique dynamics.
I have a question. Where I work, and I've been guilty of this, looking at service dogs, people that bring them in, and they need, the more I've worked with them, they do need these service dog emotional support. But the big thing is that everybody says, oh, they got an online certificate that their dog, it's not valid. It's only seeing eye dogs have valid certificates. How do you get past that?
Yeah, that's a great question. So technically there's not a actual certificate under the ADA. If they say they have a certificate, then they probably did honestly get it off of the internet. There are programs that once the service dog goes through their training, they can get a certificate saying they completed the training, but there's not an actual, this is a service dog certificate. Under the ADA though, you are legally allowed, whether you're a restaurant owner or a court, law enforcement officer, it doesn't matter. You are able to ask, is this dog a service animal required because of a disability? And what work or task has a dog been trained to perform? And I can put those questions in the chat, but you are legally allowed to ask those two questions. But there the ADA does not give an actual document that certifies a dog being a service dog. I hope that answers your question, and I'd be happy. You
That
can email
does.
us, and I'd be happy to give you some more information.
Okay, thank you.
We have a raised hand from CC Norwood who has a question.
Yes. I can't hear CC.
I cannot hear you, CC, if you're speaking.
I also put our email in the chat as well, and I can do that again. So anybody feel free to email us. NCJFCJ has an amazing amount of resources as well for military populations in the courts. And so please don't ever hesitate to email us or them to ask further questions as well. We'll be happy to answer them. We also put the survey link in the chat too. Can we assist retired military women? Yes. NOVA does not provide direct victim services or support services, but we do provide connections to agencies that do support services to individuals. But what we do primarily is provide the training and technical assistance to organizations or groups or coalitions or teams, or even individuals that are looking to support survivors. And so if you have questions following the webinar or questions on how to, clarification on the information of what we do and how we do it, please, again, don't hesitate to reach out to us and email us, and we can answer those questions and connect with you either over email or Zoom chat, a Zoom call. But I want to say that I know we're a little over time, but I greatly appreciate all of your time here today and taking your afternoon to learn more about this topic. It's not a very commonly discussed topic. Of course, I'm very passionate about it, and I know Ava is as well. So thank you. And thank you, NCJFCJ, for allowing us to be here today.
Well, thank you, Kimberly and Ava. This has been wonderful and information that's so important to share. Thank you to everyone that joined us today. We appreciate your time. We hope that you learned something. Please reach out after the webinar if you have any questions. Have a good day.